appeal on the issue. I haven't seen it, that's why I was asking Mr. Frank if you had any case where, that issue came up, the objection was posed, and, just kind of saying that, we'll come back in 2 3 months is, okay. I haven't seen any cases like that, and that's why I was asking Mr. Frank, and my understanding is that he doesn't have those.
Although the two cases that are cited in the memo, James and a statement being 7707712 and Knight versus State 21173 1 2016, both of them are Supreme Court. So those cases were instances where there were motions being made saying that the speedy trial had brought that and the discharge. Certainly in I'm talking Knight, that would be the issue. And the Supreme Court of Florida said, no, you can't bring a motion for discharge if in fact the veneer was sworn for purposes of Rder. So they clearly, Florida Supreme Court said, no, that way, that's the end of the speedy trial. For speedy trial, the trial begins when that veneer, that first panel that comes up for the questions, is sworn in. Then they said, but if you're asking when double jeopardy attaches, that attaches when you have the final panel, you've gone through all your jury selection, you've chosen 12 people and alternates, and when the court swears those 12 people and those alternates in, the Supreme Court says, then the trial commences for purposes of testimony and therefore double jeopardy attaches. So although I don't have a case where it was appealed directly here, concerning these issues, with that this procedure is involved in the courthouse on many occasions without any and the Supreme Court in Ninth versus State extraordinarily clear about the fact, delineating when the trial starts for purposes of the trial and when the trial starts for purposes of and added into that case law that has to do with how the state loses its appellate rights when trial commences. That is, when those final juries are sworn in. We no longer are able to appeal a motion to suppress that point. If the court issues us an order, maybe the argument was done pre-trial, but the court was visiting, the court didn't issue the order until afterwards, you can't appeal. You can't even take it extraordinary way. So I think one of the reasons you don't see much on this is because it's a pretty set down rule of when trial commences for speedy trial and when it commences for double jeopardy. And therefore, the level of playing field here for the state, which is at a great disadvantage at this point, there's no problem with the court swearing in a panel for a veneer and then asking them to come back at a later time according to the parties' time. They don't want to continue, then they have time to the other one, and you have time.
We all understand, we don't disagree with that being the law on when they can appeal, when speedy trial. We're not even talking about that. We're talking about, Your Honor set a date for the cutoff date for filing motion. We abided by it, and we filed motion. We're not here to give up our rights to have those motions heard, nor do we believe that speedy trial trumps the fact of us not if they want to do whatever they want to do and assign or appoint whoever they want, and then stand behind that appointment by saying, oh, we're not ready, it's not fair to do victim standing because they appointed somebody who's not familiar with the case, when there's an absolute lawyer who sat through the whole case for the last 5 years who isn't here, who's not here. So it's, and if you look at the, and I don't want to argue the whole thing, but if you look at the arguments in their notice of filing, they have the audacity to talk about the Queensberry rules of fist fighting in there. This isn't a fist fight. This is an accusation that carried the death sentence of a defendant who hasn't been proved guilty because they haven't met their burden, and we don't think he's guilty. So I don't want to have a fight with Mr. Klinger. I want to have a trial, a fair trial, have the motions heard, and do what we need to do that's right for preserving Eddie's issues, having Your Honor throw out evidence if you so find after hearing the motion, and do a real trial. That's what we're trying to get right.
They filed the motion, they filed the motion, for the office, all for it. And this court took the time and had hearings, been here for the last couple of weeks on those motions, and new rule. The court ruled, Bradley, and so at that point, we had obviously when defining the new problem. The reason why it's not any of their business plans, you don't have to be on the trial, but you cannot be this trial. So it's not going to matter.
Nothing on concern.
Therefore, the reason I put that case in your bill back, that was rejected. And in the bill back, at the time, originally, time of that television, there was no rule on the state being allowed to have an expert at death penalty interview the defendant. There was no rule at all. So the court in that case actually went outward the boundaries and said, but in this case, the court feels the state should be allowed to do it. And that's what went up on Rder, it went up on appeal. And the defense saying, no, the court had no right to allow the defense, the state, to send their expert in to see the law. The Supreme Court said, that's when they refer to the boxing situation, they're using it as an analogy, because it's not right if the playing field is not level, and that the court has the ability to level that. And they agreed with the trial court that it made the right decision of allowing the state's expert to go in and see the defendant, because they have so many experts in their decision. And they used part of the reason because it needs to be a level playing field. One side shouldn't have it as an advantage over the other side. And in that case, the court had to do something very dramatic, right? There was no rule on it. Here, we're not asking you to step over any boundary. We're simply asking you, again, as I outlined in the notice, to follow well-established law of when Sweden, when problem is for double jeopardy. The defense, in a way, has gotten what they wanted, and now it seems like a very disingenuous argument when they know that the state has got disadvantage. They say, well, we have all the motions we want to convert over. That's an issue for the court, and the court may deal with it. But from the state's point of view, we don't deserve not to be on a level playing field. To have just have these prosecutors assigned to the case when there is a way where their motions can all be heard without them having to take a defense continuum, and where the state can be ready to answer the motions, argue, and also answer them.
Your Honor, if I may, I just want to put a few cases on the record. Smart State 179, Southern 3rd, 477 is the fourth piece of this. That also discusses how the district court of appeal held that the trial had been done for speedy trial purposes when suspected jury had been sworn, pre-law dire had been done. So they said when the panel was sworn for this particular case, that was when the speedy trial was satisfied. Now, I'd also like to put on the record Casimir, C-A-S-I-M-I-R, Dunno, M-C-D-O-N-O-U-G-H. It is a third PCA case, and it's 932 Southern 2nd, 471, 2006 case. And it discusses how in that case, there was a 13-day continuance between jury selection and the examination of witnesses, and it did not entitle the defendant to discharge of charges. It also cites other cases that discuss a 24-day delay was permissible between the completion of 1 year and the commencement of trial, an 11-day delay, no showing of prejudice, 12-day delay, no showing of prejudice. So there are cases showing that there can be a time frame in between swearing the veneer and bringing the jurors back to truly start the trial. As I said, if Your Honor is not willing to wait until after the holidays, they're asking me at least until December to have somewhat of a chance to learn this case. There's just no other way. Additionally, I can get more copies.
But we're not contesting when the speedy trial starts. Or when you bring down the veneer and swear them. We're not contesting. What we are contesting is Your Honor issued a pretrial order that said all motions must be filed by 10 days before trial. We have complied. The state created this mess. They have sat on this mess for a year. And now to come in here and say, despite creating this mess, we should be given additional time, disregarding our client's rights and sitting here as presumed innocent of these crimes, is absurd. And we're willing to work around the clock to do these motions that were timely filed. I mean, I don't know what the problem is, to be honest with you. We agree that speedy trial basically is satisfied once you bring down a panel and swear them in on the state of Florida versus Denver. We agree. That's the law. We're not standing here to misrepresent the law as an officer. What we're saying to Your Honor is you are allowing the state to cause this problem and now benefit from it. They were on notice a long time ago. They were on notice, actually, when Michelle Boutros reported this thing back in October of 2022. And they sat on it. And they sat on it until we had to litigate it, until we were advised of it. And as soon as we were advised of the problem, we filed the appropriate motion. Under their scenario, they could usurp the speedy trial rule anytime they want by basically creating a problem that they knew about over a year ago. So I would ask Your Honor, to whatever scheduling you want, to do the motion that were timely filed, to do the motion and to commence jury selection. And we will take the appropriate deposition, as we've indicated, Saturday and Sunday, or whatever days we're off, if we're off any. The court indicated originally, I thought, that you would probably do the motions on a Friday. And we would go through the motions. Because we all know it's gonna take probably a month to pick a jury, not longer, because of the holidays. If they don't like a ruling of the court, before that jury is sworn in, they can take an appeal. Because we agree, jeopardy doesn't attach until the actual 12 or 14 or whatever you pick are sworn to hear the testimony. We agree with that completely. But I don't know why they should benefit. And we should be deprived of his rights. And he should sit in jail another Christmas and New Year's. No, sir.
Your Honor, I know you don't like a lot of people, but this case was just handed to us, so I might. As far as the delays that this case cites to, this is the Casimir case. Bottom line of it is, other than one case, which obviously I don't have access to, Johnson versus State, there's a flag in front of it, which obviously means it's either been disagreed with or it's been modified. every other case that this case cites, you're talking about a 12-day delay, an 11-day delay. We're not talking what the state is asking for in this case. What the state is asking for, if you look at the document that they filed, I mean, I couldn't believe it when I read it, because to me, it was an inter-office memo of how we can deprive the defendant of his speedy trial rights. What can we do in order to get around his speedy trial rights? That's what that document is. These cases are 11, 12 days. That's what these cases are that are cited in casualty. That's all the delay was, except for that one case, which I have no idea why there's the flag there. That's a little off.
Thank you. Yes.
Just in quickly looking over the case, Kathleen, they're talking about, a delay after the actual jury itself, sworn. And they're looking at delays, because now you're caught, right? Once they're sworn, trial starts. Double. The case does not actually discuss when you're still in jury selection.
You're the one who gave us the case.
But the analogy is there that if
But it doesn't apply.
So I should be designing a sport and not level of sport. I've never been, I don't do that. So, but the analogy is there, that look, if they're even finding the fact that there can be delays in the actual jury can when, there's a delay, that is okay in certain things. So, when you're just still doing jury selection go on forever. I mean, the court could, if it wanted to, bring panels in here and there, just as you over to see whether or not they're going to be able to have the time, the ability to stay on trial. I mean, certainly, in the state of Florida versus Nicholas Cruz, it took us 3 months, I believe, maybe 2.5 months to get it to this. Panels came in at all different times during that trial. That was in 2022. So, these rigid rules about how long a delay can be when you have a jury apply more to when the actual jury is sworn and not the near panel is sworn in order to start the process. And so, again, it's usable to see they're following your orders. There is no appeal, and it is very reasonable for us to at least ask the court to come up with a way that it would allow us all extra time. They don't need to continue this. And they can do the motion. There, it's not foul play. It's not trying to get around the rules. It's simply following the rules and doing what's fair to the level.
So what days, assuming we're going to start, what days do you start getting jury tomorrow? Or what days I'm swearing the jury in one way or the other, right? So whether I agree with the state and the whole law on it or not, we're start picking that panel tomorrow. I don't know when you're anticipating. I know with this, Bradley was here. She had issues with child care and everything else. She was knocking off all kinds of days that it was 2 weeks into Christmas. And, I don't know exactly when the good days were, but I do know that she wanted to put a substantial number of days off for the holidays for she had minor children in school. I don't know if defense has the same position as the state did. I don't know what your position is, what your opinion is. We're starting jury selection.
Your Honor, I did speak with, local counsel for this case, and written out the days that we would not be unavailable. I don't know what the Bradley's availability was, but there are a few days in there, and obviously the holidays, are given consideration as well, but there are a few days in there.
What days are you unavailable?
So obviously tomorrow, as the jury, I will be here, but I know for this, it's not able to be here, but myself and Ms. Thomas will be here. Thursday, not be here.
So what day are we talking about now?
I'm not talking about the 19th of October.
So, state's available on the 18th,
Most of us, yes, so we will be here.
19th.
Ms. Collins is not available. So
What about on the 23rd?
I know, that some of us have unavailability in the afternoon.
What's the unavailability?
I do have
It's not me, it's.
no. And then the 26th, both of my patients are unavailable.
We're good on the 24th. 25th. I'm not on the 26th.
Correct.
So far we have 18th, 19th, 24th, and 26th. And you're saying you're available, so.
Yes.
What about the rest of our?
We're fine.
31st,
We're
so 18th, 19th, 24th, 25th, 30th, 31st.
18, 19, 24, 25, 30, 31.
You're available. And October, you guys available for the state?
I just have one doctor's appointment Thursday, late afternoon, Friday, the 19th. But it should be an hour, and I don't know if all of us need to do the jury selection, but we didn't contemplate it, but I don't.
Man, I'm asking you.
Oh, yeah, we're fine. No, we're fine, we're fine.
Good to go.
Yes.
So how about November?
And just so I'm clear, you're doing this, just, you're not moving one way or the other what we're doing. So I have on November 2nd, Your Honor, that I'm unavailable in the afternoon. I just cannot remember why. I think that might be a doctor's appointment.
You're good on the first,
Yes,
not on the second. How about we do the sixth?
we do this, if all parties for the state are available.
We do the 13th.
Your Honor, I'm out the 13th, 14th, and 15th.
I'd be good on the 16th.
Yes,
How about we do the 20th?
all parties are available, the 20th, 21st, and 22nd, and obviously the office is closed. the 23rd.
So Judge, based on the previous schedule we had reached with Ms. Bradley, I was planning on leaving the 17th and being out that week of Thanksgiving.
Thank you. We'll get to you in a second. How about the last week in November?
Mr. Curtis is unavailable that entire week.
So regarding the defense in November, are you all good the first?
Yes.
November first.
Yeah, we did it.
Yes. How about the 6th, 7th, 8th, 6th, 7th, 8th, and 9th?
Some combination of us.
Yes.
We're fine.
Good. Then, next is the, either 13th or somewhere, state's not available, then we come back on the 20th, the 1st, and 22nd, but I thought I heard Ms. Reagan say she's not available. You mentioned the 17th, is that right, Ms. Liberty?
Yes, Judge, based on our last schedule, I had planned to go home for the 17th, the week of Thanksgiving.
So it's the 17th, 20th, 21st, 22nd, so you're not available those days.
No, Judge.
And the last week, 27th, 28th, 29th, 30th of November, you're good? Then?
Yeah.
Yes. Ms. Liberty, you're good?
Yes, Judge.
All right, how about December? How about the
Your Honor,
state in December?
Your Honor, the only unavailability that the state has is starting December 21st through the 31st.
21st through the 31st are not available, otherwise. And how about civil defense? First through 23. Yes,
Yes.
come back into January, the first week of January.
Ms. Collins is good, and then I think Mr. Griffiths is checking his calendar.
I'm good from January, potentially out the 29th through February 2nd. Actually, 29th through February 9th. I have to double check those dates.
So the state's relatively as good as January.
I'm gonna have to double check my schedule for February. I get confirmation of date for February.
Days, in October, November, roughly, half the month of December through the 20th is good. January is good. February, not sure. So, we'll figure this out. My concern really was not specific days. I try to work with the attorneys to get another something like that. But I was more trying to gear up for vacation season and different Christmas and Thanksgiving holidays. I haven't read your case, I'll take a look at it. How about with regard to Monday through Thursday, I'm not reading the section on Fridays, that's the way I just like it. Discussed it with the council. I wanted to all 5 days, Mr. Bradley, go back to the rest of the council. That's council also said they have certain things they might want to have happen on Fridays.
We're good with Monday through Thursday, and obviously we have motions that we need to have heard. I'm not opposed to using some of the Fridays, but obviously we need time to one, learn the motion from the case, and also prepare on some of the Fridays that we would have to utilize, but we're not opposed to utilizing some of the time on Fridays. But I think we would have to obviously review the case, know the evidence, and see which motions we We're back December 4th, we start with full longer after that. What's best team on your case, and that way myself and my co-counsel can utilize their time effectively the rest of this month and next month we can start with council are not available.
What time is it? What time is it? And we have a moment.
To be recessed. Can I see you, I'll see you talk over a minute. I'll be back in a minute.
Thank you, Your Honor.
I got a record of work, but because the Senate is counsel resists their attorneys. So, did it come to any resolution?
Kind of. There was a suggestion of bringing paneling in the morning and recessing in the afternoon, so let's just say you get up to speed. We could live with it. If the court. But, we proposed another alternative, but they need to talk to higher ups. And maybe we approach. Sure.
You have some ongoing discussions that you're
Yes.
having. As far as starting with the jury selection, counsel Claire asked a question, and I just indicated maybe we just go back to the podium so we can talk more to the court here. So the defendant is here, but you mentioned about a larger courtroom. I am able to get one if you want that one. I don't know if you or not, but if you think that's a good idea. I'd love to check for Bowling at this point. It's the two doors down. It's 4840, so that's still, it's at 11. You said you accommodate whatever I wanted. I did speak with the jury room yesterday. They have jurors that they reviewed tomorrow. And we can do that if you just get a large panel. I think we originally thought when Bradley was still on piece about going over there and bringing 100 jurors at a time. So I don't know how we fit in there, but we might be able to get more.
Your Honor, I will try to update you there, with the time. I took a couple of months and utilize some of those programs. We said about 5, maybe 7 jurors at a time. So that time.
That's when I tried first, we were in that same type of courtroom, but on the fifth floor, they're identical, and we were able to squeeze in 70 of those numbers.
I thought, Gary, when we went over there, we thought it was close to 100. That's great. 100? We'll have to look at that.
I'm not saying
for the, no, actually, it wasn't Texas. I'm not saying for the whole, I guess we could have it for as much as jury selection as we want, but I was thinking, or at least preliminary.
At Take 5, you stay in your car because we're faster than you think.
Oil change is done. That was so fast.
She said we have this quote whenever I wanted to, how long I wanted to. And I said I just want for some or all of the jury selection, whatever we want to be able to accommodate for. Right. So we can. Florida, Gary, later today, to see how many jurors we get. Show signs. Count it out, but I hope we do that. Already because we're being talking about home again. Again, you make things different. You walk over and interact yourself.
But we had a problem in that courtroom, which is the fact that the chains on the defendants and stuff like that, I don't know if they were still beyond. And that's why I think we had to limit to the amount of people, because you couldn't put them in perspective.
We just,
Well, it'd be like street closed.
Yes,
right?
yes.
It's not gonna be.
Yes.
And there's just one thing that goes to the eight.
So if it's 60, I'm sure we get way more than something. That's what you're rolling.
We're rolling.
it's in there.
We have the same numbers, but we're wrong.
Your Honor, we're fine with whatever, Your Honor, obviously, we're agreed with the larger courtroom, that was allowed more room for the state to have another table, obviously, it's smaller for the three of us. There's multiple defense counsel, and those tables in there are bigger for defense counsel as well, and then obviously, for more jurors, to see their availability.
If you try the case from here, is this not sufficient for you?
If we could have a bigger table, we're fine, because there's three of us, but otherwise, whatever works for Your Honor, we will make it.
I'm agreeing, I'm supposed to say the goal, and we actually not be organized. I always want to try to do.
That's fine.
I'll have to find out who's going to do it. So, I was looking at these dates. Trying to come to some understanding of the only way that we went through was like just for the hardships going over the dates, see how the jurors would get. And what did they imagine, number of jurors that you thought you wanted to have before you actually started with the attorney's question? I would suggest between 100 and 125, as we said, 50.
We're fine with that.
So,
The reason the funds are costing them higher than the big.
so if we come back, if we put it through here, we put the 19 and go through this. We start with the hardships, until we have that magic number, so we're on the high side, 150. We want to, how many people would you want to discuss this with? The attorney speaks, and we want it smaller, or we want it larger, or 100. So it's 150. We want it smaller, actually smaller. Which really is the best number.
Your Honor, that one is that trying to always had, like, 50 to 60 at a time that we could.
So, if you're away, we need to be, the board of instruction question.
So, thank you.
How long do you take the question? Usually,
General law, Rder, Mr. Benjamin, and the death qualifying.
Your Honor, again, I don't know the issues of the case, I could not even begin to approximate the amount of time. Me, that hasn't been discussed yet, but likely, potentially one of them.
So, assuming that that's what it takes, we do it here, we have something small, I don't know if we don't have 20, 25 years. We've never done that, so I think it's a balancing case with, assuming we did that, we came back and here for it, and we broke it up into groups. If it's 50, you're talking 3 different board hours. And that's where you can hold the conversation, that's for the and if you're doing that and you're splitting it up, correct? So I'd say one, two, split up, not so much the person doing it, but the standard board iron and then the depth company board iron, you know. Well, I've never done it where it's all mixed in, to be candid with you. Because I don't see any reason why I couldn't do that, I've never done that. We've always broken it up, and I think in the last trial with Bradley, she wanted to do the depth company portion first, and the defense didn't.
We did general law iron first, and then that's qualifying.
I think Ms. Bradley thought of doing more people in the depth company who did that first. That was her thought process.
I think the court agreed with Ms. Bradley, taking off the case to do general law iron first, and then that's qualifying.
That's what we did in the last trial, but it's going to happen in this
No,
trial.
I understand.
I believe that Ms. Bradley wanted to that portion done first, only thing done first. So you can find that, and we'll talk about it. But it would seem to me that we're just going to be a couple of days just trying to get up to 150 jurors, hardships, and I don't know how much detail I'm going to do on here people on the trial, obviously, so 2 of the 3 defense counsel on here, but we went through a written question where I asked the jury to go through the questionnaires, and I also put the attorneys out the witnesses, and this time we have long witnesses. You're gonna read it, last night you want that something. Right? Go ahead. You'll read it.
Whatever the court decides.
I'm asking you.
So are you going to read it at the time you're time qualifying them, or you're waiting, you're saying?
I'm gonna wait.
Okay, that's fine.
My thought is, I think the last time we did it, I did read it then, as a statement, read the charging document. And I'll probably still do that with the preliminary instruction I'll give, no research, things like that, no use of cell phone. I'll go through those and really silly instructions. My functioning, the attorneys are on the cruise group for the time. I'm not going to ask you a question about whether they know, I will ask a question whether anybody knows what's in it. If they do the work, if they know what's in it, other than what it is, we could bring them up to time. By trying to stop them, we see states. To that issue. I'm going to take
Back to allowing us to there. That extremely, we can get rid of some, and we will, so we can have. We don't know what happened in the trial, now. And remember, for tomorrow, we'll do that in December. Give us some.
instruction for the standard for the dialogue. We talked about defense, in the right, not testifying. Yes. Yes. This is your instruction on, reason about instruction. So. Yes. All right, so you talk some more. Anything else to discuss now?
Your Honor, what time do you start at 9 o'clock?
We can't get through what you're talking about 9:30. So I say 9:30. And next door, over that, we call it
do have you asked me anything else? Just one question to the court on the jury. Does the court have an idea of when those jurors, like tomorrow, can go through and for hardship and so many years back and back, and an idea of when you might be bringing it?
We have to get 150 by all the people that are on the area and do the phone numbers. And let them know the sporadic schedule.
Yes, sir. So you want to speak one other thing very quickly?
So last Friday, when I had brought up the idea of the court doing an inspection of the investigation that was going on with sort of afterwards, there was a question of the defense counsel Liberty regarding which investigation you were talking about. Yesterday, there was an email chain between your JA, myself, and Robert Trackman. Mr. Trackman was saying that he has an outstanding motion for discovery of supply. And I responded with, is that for himself? Is that from the investigation that's going on, what he represents the defendant's mother, or whether or not there's something that happened in this case that I don't know about? I didn't get a clear answer from him regarding where is it? Where is it? So I'm not sure exactly because I didn't have access to Oxford.
Why don't you talk about that? If you recess from there, give you a chance to talk about it. You know, before I let you go, Bill, Mr. Dempsey, Dave, any discussion regarding settlement? No discussion, correct?
There's been no further discussion.
Dave hasn't offered anything?
No.
And you haven't?
We did offer something, when we met with the state attorney. And they said they would get back to us and I said,
You're talking about the meeting we had
Yes.
with the state attorney.
with the state attorney. Yes.
One last thing if I may. When I didn't know what the scheduling was going to be, I subpoenaed them tomorrow, if that's correct. I just want to make sure I should call them off, because we're certainly not going to be doing any testimony and any motions. I just want to make sure that's the case.
They want to swear in the panel, we can do something afterwards, but bring the jury back, you know, a couple months later.
I'll cancel.
You're not ready on anything, correct? You're not telling me you're ready on anything.
No, no.
We'll do it. Mr. Devens? Mr. Devens? Good morning. Good morning. I appreciate you standing, and that's fine if you're comfortable, you can stand, if you want to sit, you can sit. It's up to you. So just Devens, you've heard, what's going on here, this discussion we've had, having, I just asked the attorney to review possible resolution in case they indicated, that they had made an offer.
So they can
talk
If we could look at
your attorneys also asked me to go forward on the trial. They want to move on to, I brought up that pursuant to this notice to the court and the parties that was filed by the defendant, by the state attorney, that there are 30 outstanding motions that were filed recently, last 2 weeks or so, right? And there are 22 new state witnesses. Those new state witnesses have not been posed as of yet, and we haven't had any hearing on those 30 motions. I asked your attorney if they're ready to file, and they said yes, they want to go to trial, and counsel may be concerned about that. They weren't asking for continuance, and that they wanted their day in court. They also want the motions for exactly how they're going to do that. They indicated. Did you hear that? Yes, sir. And have you had an opportunity to discuss that issue with your attorneys? the answer to your question. Is this what you want to happen? So the reason I ask it, let's say things don't go well for you, and we come back and all these witnesses haven't been exposed, or all these motions haven't been heard, or something along those lines, and you're in the middle of the trial, and it doesn't go well for you. I don't want to, have an issue with them coming back saying, hey, my attorneys were ineffective. I made a mistake or something along those lines because they gave me bad advice or something along those lines. That's what I get. So you have an opportunity to discuss this issue with your attorneys about whether or not you want to take over the depositions first, have the motions heard first, or not. You had that discussion, correct? Yes. And they've answered all your questions. And this is what you want. Right, you're on board with this decision, so I assume you're recommending it, I don't really know, but you're on board with this. You're in agreement, correct? Just like I'll ask you, right? Certain things I'm going to ask you, we want to make sure we're all on board with the same things. It's your case, your trial, you're going to table counsel, with your court here, and the court is more on the phone, on Zoom. It's delivery, but it's ultimately your trial. I want to make sure you're good with it. All right, so periodically I'm going to stop and ask you, just make sure you're all right. Just like you did before.
We want to make it since we filed that motion this time, send it to the court order, we're not giving up that much. Oh, okay.
Some of the motions expressed to be heard during
Yes.
trial.
Yes, absolutely.
During trial.
Yes, sir.
The evidence in.
Yes, sir.
We'll see what happens. I don't know exactly what you do. But again, I don't know if you have 22 depositions and you take those depositions and you do it ongoing during the trial and you say something in opening statement that you might not have said, that you had all the depositions done. I don't know what's going to happen. We understand. I'm always very cautious about starting something, very serious matter without availing ourselves of all the pre-trial motions and getting those things involved.
Your Honor, if I may, just again, because we're coming in at the 11th hour, in our brief review case and the script reminded me, we still have the new charges that Mr. Evans, new charge that he picked up. We're obviously reviewing that evidence, we're going to be filing a decision. But it's my understanding, again, in my brief review of the evidence so far, that we do not see still evidence that potentially could come in this trial. So we'll make sure that any of those charges and decisions or motions we need to deal with that charge in this case is filed immediately. Read everything this week. So that actually, I guess, have the same effect that Your Honor just brought up on certain things that might take place. I also do know that one of the witnesses that was listed, the reason that witness was listed from the get-go from digital forensics is because I guess there's going to be a warrant done on the vehicle to download from the telematics. That would be something that we can do in the first instance. I just wanted that on the record.
It's just something that I'm trying to figure out how we're going to handle this and what we're going to do. Why you're here first. I know you're very position, but there's a balance. It has speedy trial rights, you have the right to process, you have the right to fair hearing as well. I understand all of these things, just trying to believe something that works.
I understand, Your Honor. I just want to make sure that, the prosecution case, we're not violating our oath. We obviously have to be prepared, and God forbid something, or in this case, that we weren't aware of in the original case, we're going to end up in a position where maybe we don't disclose something. So we want to make sure that we don't get to that point again. We're here to make sure that this trial is done right, that there's no issues, and that's why you have 3 prosecutors on the case. And so, I just did this in Judge Holden, AP Gregory Cunningham, where we brought the jury back during in July, they came back in September. So they did ask for a little bit of time. We will in no way, shape, or form have an advantage by that because we tried to deliver this case for 5 years and we're asking for a month.
Thank you.
See you tomorrow. We have stuff to discuss, right?
Have a good day, Judge. Thank you.
Thank you. I appreciate it.
Take care.